procedurally inadmissible, they are also unworthy of the court's attention when they did not merely restate the applicant's flawed arguments. They sought to obfuscate the proceedings further with meritless arguments and misreadings of the respondent's case. And of course, an even more flagrant example of the applicant's cavalier attitude to these proceedings can be found in its filing duplicative claims before the East African Court of Justice. The applicant failed to disclose these parallel proceedings, disingenuously asserting that there was no ESCJ case when it lodged its application before this honorable court. Yet, within a month, the East African Court of Justice filing was submitted, proving the applicant's knowledge at the relevant time. As we established in the rejoinder, the applicant even attempted to recycle these proceedings documents before the East African Court of Justice, providing irrefutable evidence not only of its attempt to secure duplicative relief, but also that these cases are inextricably linked. It should therefore be clear that the applicant's attempt to conceal its litigation strategy erodes the principles of good governance and transparency essential to international adjudication. We could go on. The procedural record is replete with such guerrilla tactics from the applicant. Suffice it to say that such conduct is not only procedurally improper, but also profoundly corrupt. To firmly reject such tactics, which, if left unchecked, will diminish its standing and invite further attempts to manipulate these proceedings. Let me also briefly deal with the applicant's flawed approach to this case's lack of legal basis. Beyond its disregard of the applicable procedural rights, the applicant's approach to the case legal issues can only be described as scattershot and impressionistic. The applicant seems to be under the impression that it suffices to invoke a bewildering array of legal instruments and alleged norms without demonstrating their applicability, let alone their ratification or even binding nature upon the respondent. Needless to say, this is not how international justice works. Well, we will later elaborate on why the court lacks jurisdiction to address the merits of the applicant's case. I would like to shortly focus on general approach adopted by the Democratic Republic of Congo in this case. In brief, the applicant's excessive and unfocused strategy appears designed to overwhelm the court with sheer volume rather than to engage meaningfully in its jurisdiction and substantive standards. Indeed, the applicant has failed to establish even the most basic elements of the court's jurisdiction, including the existence of a bona fide legal dispute at the time of filing. President of the court, honorable judges, this lack of focus was even more illustrated in the applicant's failure to entertain or even acknowledge some of the preliminary objections raised by the respondents. Parties in international proceedings have duties. In particular, they should do their utmost to place the court or the tribunal in the best position to rule fully upon the case. This ensures efficiency and the fair settlement of disputes, as well as the legitimacy and the strength of the resulting decision. By contrast, the applicant has opted to raise as many arguments as possible while ignoring the respondent's legitimate objections, and is now simply hoping that the court will somehow sort out its case. its last-minute attempt to remedy this lapse in its inadmissible observations only compounded the limitations of this approach. Chief amongst the issues that the applicant has failed to deal with, the required seriousness, is the exhaustion of local remedies. This cornerstone requirement of international human rights law, deeply enshrined in this court's own jurisprudence, has been entirely bypassed, even though there is absolutely no dispute that the burden of proof is on the applicant to prove that such remedies have been exhausted or are not required. The respondent has dealt at length and in details with the judicial mechanisms that were and still are available to the applicant and the individual it purports to represent. These mechanisms are fully operational, accessible, and effective, a fact that the applicant has utterly failed to rebut, preferring to believe that it is not bound by the usual rules of admissibility. This alone would render this application inadmissible. The applicant's treatment of this critical issue has not been an exception. Its general attitude has been to offer no coherent rebuttal of the key jurisdictional and admissibility issues, but instead to rely on vague, impressionistic assertions unsupported by evidence or legal authority, as if the mere invocation of human rights could substitute for rigorous legal argumentation. President of this tribunal, members of the tribunal, this case is therefore remarkable, be it for its procedural chaos or for its substantive deficiencies. We do reckon that this case is remarkable, but it's couched with a lot of procedural chaos and substantive deficiencies. As I now leave the floor first to Professor Dapo Akande today to set out arguments on lack of jurisdiction, and then tomorrow to Dr. Owiso, who will deal with the inadmissible nature of the claims made in these proceedings, it is essential to underscore that the procedural and substantive deficiencies of this case form a critical background to our submissions. The lack of coherence, procedural lapses, and disregard for established principles must guide this court's understanding of why the application is both inadmissible and outside its jurisdiction. Thank you, Mr. Presiding Judge and Vice President of the Court, and the members of the Honorable Court for your kind attention. And I would invite you, Mr. President, to call upon Professor Akande to proceed with the issue on jurisdiction. Thank you very much.
Mr. Vice President, members of the court, it's an honor to appear before you today and to do so on behalf of the Republic of Rwanda. My task this morning is to set out the argument that the matters that are covered in the application filed by the Democratic Republic of Congo are not within the jurisdiction of this honorable court. I begin by stressing, as our agent has already indicated, that Rwanda has deep respect for the high functions which this court is called upon to fulfill. Rwanda agrees that the court has an important role to play in the protection of human rights in Africa. However, that important role is entrusted to the court strictly within the terms of the African Charter on Human and People's Rights, and particularly within the terms of the protocol on the establishment of this court. The court, as a judicial body, one of the highest judicial bodies on the African continent, performs its functions in accordance with the specific mandate that has been conferred upon it. That specific mandate sets out and defines the jurisdiction of the court, and as will be explained by my colleague Dr. Owiso tomorrow, also sets out the circumstances in which applications are admissible. The court itself recognizes the importance of only determining the merits of applications that are filed by parties in circumstances where those applications fall within the jurisdiction of the court and are admissible. This is why Rule 49, Paragraph 1 of the Rules of Court, adopted by this court, provides, and I quote, "The court shall conduct preliminary examination of its jurisdiction and admissibility of an application in accordance with the Charter, the Protocol, and these rules." The court faithfully applies this provision in practically every case that is brought before you. And as is evident from your judgments, you conduct that preliminary examination carefully. So in raising the preliminary objections now before the court, Rwanda has done no more than to assist the court in the task which the court is called upon to engage with. As this matter is the first interstate case that has been filed before this court, it is even more important that questions relating to jurisdiction and admissibility are examined with rigor. What is at stake here is the question of the scope of the consent that states like Rwanda, which have become parties to the protocol, have given to the court's jurisdiction. The question is this: in relation to what exactly have these states agreed to adjudication by this honorable court? The applicant has argued that Rwanda is taking a formalistic approach to these matters of jurisdiction. But that is because they wish to play fast and loose with the terms of the protocol. What we argue for is that the court should do what it always does, which is to stick strictly to the competence that has been conferred upon it. Mr. Vice President, honorable members of the court, Rwanda submits that the application filed by the applicant falls outside of the jurisdiction of the court in two broad respects. First, the claims of the other side fall outside of the material jurisdiction of the court. Or to put it in other terms, the claims are outside the subject matter jurisdiction of the court. Second, the claims also fall outside the territorial jurisdiction that is conferred on the court, since the violations that are alleged by the DRC were not committed on the territory of the Respondent State. Mr. Vice President, members of the court, let me begin our submissions by first addressing you on the issue of territorial jurisdiction. In our written pleadings, Rwanda first addressed the material scope of your jurisdiction. We fully maintain all our arguments that show that this case falls outside the material jurisdiction of the Honorable Court, and I will address those issues in a moment. However, in these oral hearings, we begin with the submission that the matters brought before the court fall outside the territorial jurisdiction of the court. We start here because the points are very straightforward. Your jurisprudence on this point is abundantly clear, the insistence that the alleged violations must have taken place on the territory of the respondent state has been so consistent that one can hardly misunderstand it. However, somehow, the applicant claims that this requirement does not exist. This is a most unusual case that has been brought before this court. It is not only unusual, it is unique. The aim is to greatly expand the jurisdiction of the court to matters that are beyond what you have consistently found to be within the limits of your jurisdiction. The case is unique, not because it is the first interstate case brought before this court. It is unique and it is inappropriate because it aims to do something that you have consistently held is not to be done. The case aims to bring within the jurisdiction of the court matters which did not occur on the territory of the respondent state. There's an important reason why the territorial jurisdiction of this court is confined to facts that occurred within the territory of the respondent state. It is only in that space that the respondent has such control that it can actually fulfill its obligations under the relevant treaties. The attempt of the applicant to change the clear requirement of territorial jurisdiction set out by this court is an obvious attempt to involve this court in matters concerning the use of force and matters implicating challenging issues regarding the maintenance of peace and security, and it should be rejected. We request the court to find that this case, which relates to matters that did not occur within the territory of Rwanda, falls outside the territorial jurisdiction conferred on the court. In each case that is brought before this court, you carefully consider whether all aspects of your jurisdiction have been satisfied, and you have always indicated that one such aspect of jurisdiction that must be satisfied is territorial jurisdiction. You have also defined that territorial jurisdiction very clearly and in the same way. In so many cases, more cases than we can cite, but we cite many in our preliminary objections and also in our rejoinder, you have said that there is, and I quote your jurisprudence, there is territorial jurisdiction insofar as the violations alleged by the applicants occurred on the territory of the respondent state. End quote. You've held that in many cases. In other cases, you have said essentially the same thing by holding that you have, and again I quote, several cases from the court, you have, quote, territorial jurisdiction since the facts of the case occurred in the territory of a state party to the protocol, namely the respondent state. End quote. In both of these formulations, the key point is that the alleged violation of human rights arises on the territory of the respondent state. The applicant seeks to avoid this key point and this court's consistent jurisprudence by making a number of arguments, all of which are ultimately misguided. They say that the relevant criterion is not that the violation occurred on the territory of the respondent state, but in their view, what is key, and I quote their reply, what is key is the state party status under the relevant instruments conferring such jurisdiction on the court. But this argument is plainly wrong. In the first place, there are many cases where this court doesn't even mention that the facts occur on the territory of a state party when dealing with territorial jurisdiction, but simply indicates that there is territorial jurisdiction because the facts occurred on the territory of the respondent state. Second, to say that the relevant criterion for territorial jurisdiction is the status of the respondent state as a state party to the protocol is to confuse territorial jurisdiction with personal jurisdiction. But the court is not confused. In each and every case, this court first examines whether it has personal jurisdiction. And with regard to that issue, whatever the small deviations of the wording, the court checks to make sure that the facts have occurred in the territory of the respondent state. Not just any state, not just any state party to the protocol, the court always determines that it has territorial jurisdiction because the facts have occurred in the territory of the respondent state. The applicant's confusion of territorial jurisdiction and personal jurisdiction is even more evident in its argument that if the court were to accept that its jurisdiction only relates to matters occurring within the territory of the respondent state, in their view, they say this conception of jurisdiction ratione loci could only apply, and I quote from the applicant's reply, could only apply in respect of human rights violations committed in the territory of a state party, in the territory of a state which is not a party to the protocol or the charter. So they say it could only apply in respect of human rights violations committed in the territory of a state which is not a party to the protocol or the charter, end quote. This is very confusing, because if the state is not a party to the protocol or the charter, the court would have no personal jurisdiction with respect to that state. So how could this concept only apply in relation to states not party to the protocol or the charter? The two requirements, that one, for personal jurisdiction to exist, the respondent must be a state party to the protocol, and two, for territorial jurisdiction to exist, the conduct must occur in the territory of the respondent state, are very clearly stated in the information that this court presents on its website about deposited the Article 34(6) declaration in cases involving individuals and non-governmental organizations. The case must involve allegations of human rights, and those alleged violations must have taken place in the state concerned after it ratified the protocol. Those alleged violations must have taken place in the state concerned after it ratified the protocol, unless alleged violations are ongoing, end quote. Moreover, when the court presents information about the procedure and the conditions relating to filing a case, the court specifies very clearly, and again I quote, territorial jurisdiction requires the alleged violations to have taken place in the state concerned, end quote. None of this could be any clearer. The applicant argues that if the position of Rwanda, our position, that the alleged violations must occur in the territory of the respondent state, if that position were to be accepted, They say this would render the African human rights protection system devoid of all substance and usefulness. But how could this possibly be the case? After all, in every other case before this court, the facts have occurred in the territory of the respondent state. This has not made the African human rights protection system useless, as they suggest. Indeed, the system is working. It is the applicant that is trying to upend things by bringing the sort of claim that has never been brought before this court. It is their conception of territorial jurisdiction that would radically change the African human rights system. This is particularly so as the claims of extraterritorial violation are, as in cases like this, they're likely to be brought in matters which implicate peace and security and therefore beyond the court's jurisdiction. We submit that the court should not depart from its established jurisprudence, and the court should hold that this case falls outside the territorial jurisdiction conferred on the court because the facts occurred outside the territory of Rwanda. Mr. Vice President, members of the court, permit me now to turn to our submissions that the matters brought before the court are outside the material jurisdiction of the court. The claims of the applicant fall outside the court's material jurisdiction in two separate and distinct ways. First, the matters that are included by the DRC within its application were not the subject of a relevant dispute between the parties at the time when the application was filed. So the matters were not the subject of a relevant dispute between the parties at the time the application was filed. Rwanda submits that the DRC brought its claims in a rather hasty and precipitous manner. We submit that the court only has jurisdiction in interstate proceedings where the matter submitted to the court was already in dispute at the time of the filing of the application. The applicant has failed to demonstrate that such a dispute on the claims brought to this court, they failed to demonstrate that such a dispute existed between the parties at the time the application was filed. So that's our first argument on material jurisdiction. The second reason why at least some of the matters submitted to the court fall outside the court's material jurisdiction is that these matters do not, as required by the protocol, they do not relate to a relevant human rights instrument ratified by Rwanda. So we submit that some of the matters submitted to the court do not relate to a relevant human rights instrument ratified by Rwanda. The scope of the court's jurisdiction is set out in Article 3, Paragraph 1 of the protocol. As with other international courts, the jurisdiction of the court is constrained by what states parties to the instrument establishing the court have consented to. It is this provision, Article 3, Paragraph 1, that sets out what the states parties to the protocol have consented to, and it is important for the court to stay within the limits of that consent. It may be useful to remind ourselves of what Article 3, Paragraph 1 actually says, not least because at times one gets the impression that the other side have paid little attention to the text of the provision. So with your indulgence, let me read it out. It provides, and I quote, "The jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation and application of the Charter, this protocol, and any other relevant human rights instrument ratified by the states concerned." Mr. Vice President, honorable members of the court, let me now address these submissions in detail. Our first submission on lack of material jurisdiction is that the court lacks material jurisdiction to consider matters in the application filed by the DRC because in interstate cases such as this one, the jurisdiction of the court only extends to disputes which existed between those states at the time when the application was filed. I will first show that this requirement of the existence of a dispute is one that applies to the jurisdiction of this court in interstate cases. I will then show that at the time when the DRC filed its application, there was no dispute between the parties with respect to the matters that fall within the application. Now, the requirement of the existence of a dispute at the time of the filing of the application follows first and foremost from the text of Article 3.1, which I have just read out. That provision does not only say that the jurisdiction of the court extends to cases submitted to it, but it specifically mentions that the jurisdiction of the court extends to, and I quote, disputes submitted to the court. This means what it says. For a dispute to be submitted to the court, it must actually exist at the time when the application is brought. This requirement that there be a dispute between the parties relating to the subject matter of the case and existing at the time of the initiation of the case is consistent with the practice of other international courts and tribunals that deal with interstate proceedings. In fact, the language of Article 3 of the protocol, when it speaks of submission of disputes to the court, is reminiscent of the language of the jurisdictional provisions of the statutes of other international courts that deal with interstate cases. In particular, Article 38(1) of the Statute of the International Court of Justice similarly speaks of the functions of that court, the ICJ. So Article 38(1) of the ICJ statute speaks of the functions of that court as being to decide, and I quote, such disputes as are submitted to it. Such disputes as are submitted to it. The similarity in the language to that in the protocol is obvious. The protocol of this court speaks of, I quote, disputes submitted to it. The statute of the ICJ speaks of such disputes as are submitted to it. That similarity is not accidental, and frankly, is not surprising. The drafters of the protocol of this court, of course, were well aware that in Article 5, the protocol contemplated that the court would preside over proceedings brought by states against other states parties to the protocol. They accordingly, and certainly, took care of adapting the protocol's language to the deference that is typically shown to sovereign states in international legal proceedings. Now, it is also not of great surprise that the requirement of a dispute has not so far been elaborated upon in the jurisprudence of this court. After all, this is the first interstate case that has been filed before this court. And so this court has so far, for that reason, not yet had opportunity to consider what jurisdictional issues arise in the specific and different context of interstate proceedings. If I may say, what is surprising is that the other side suggests that the court should deal with this case just as it had dealt with all the previous cases, though those cases were brought by individuals against states. There are features which are specific to interstate proceedings, reflected in the drafting of that provision, which, as we've just seen, borrows from the language of the ICJ statute. And it is important for those features to be considered in these particular proceedings. Now let us look at the practice of other international tribunals that have in their founding treaties comparable language specifying that the function or the jurisprudence of the court extends to disputes submitted. Let's look at the practice of other tribunals that deal with this language of disputes submitted to the court. The International Court of Justice has held that two things follow from this language of submission of disputes. First, and I quote, the court has said, the existence of a dispute between the parties is thus a condition of the court's jurisdiction. I quote again, the existence of a dispute between the parties is thus a condition for the court's jurisdiction. This is in the case between the Marshall Islands and the United Kingdom. And with your indulgence, Mr. President, all the citations are in our pleadings, and we will also submit them with the notes of these oral pleadings, the citations to these cases. So that's the first thing. The existence of a dispute is thus a condition of the court's jurisdiction. Or as the president of the ICJ stated in that same case, and I quote, the existence of a dispute between the parties to a case is not only a condition for the exercise of the court's jurisdiction, but more fundamentally, a condition for the very existence of that jurisdiction, end quote. The second thing that follows from this language of dispute submitted, is that the court will only have jurisdiction over a particular claim where there was a dispute between the states concerned at the time when the application was filed. The ICJ has put it in this way, and I quote, in principle, the date for determining the existence of a dispute is the date on which the application is submitted to the court. The ICJ has held this in several cases, exactly that same language, and you will find the citations in our pleadings. The court, the ICJ, stated that this condition follows from the language of its statute. Language that we have seen is very similar to the language used in Article 3 of the Protocol of this Court. The language in both instruments is of a dispute being submitted. That submission happens when the application is filed. However, the thing that is being submitted, the dispute, it must actually exist at the time. The alternative is a logical impossibility. States cannot submit a dispute that does not exist. Moreover, states cannot use the filing of a case as a way of manufacturing or creating a dispute. The dispute must exist, and then it is submitted. The applicant in this case argues, despite the clear language of Article 3, that there is no requirement of the existence of a dispute. It seems to be their wish that the court reads Article 3 as if those words, which speaks of disputes submitted to the court, are not present. But the words are there, and the court must give them meaning. It's not entitled to ignore them. The applicants have come up with all manner of arguments to counter this requirement of the existence of a dispute at the time of the filing of the application. They argue that Rwanda's approach is one concerning what they call traditional litigation. And they say that we confuse that kind of litigation with the requirements of human rights litigation. They contend that the procedural requirements of human rights litigation, particularly before this court, are, I quote, generally flexible. That's what they say. They say that the drafters of the protocol, and I quote their reply, intended to create a court that is flexible and adaptable in the exercise of its jurisdiction. End quote. And in this regard, they seek to draw a contrast between how states express their consent to the jurisdiction of the ICJ and this court, as they also draw a contrast between the missions of both courts. In their view, the requirement of the existence of a dispute is pure formalism. Furthermore, the applicants place reliance on the provisions of the African Charter relating to and the practice of the African Commission of Human and People's Rights. They place reliance on the provisions of the African Charter relating to the practice of the African Commission of Human and People's Rights to suggest that even in interstate cases, there is no requirement of the existence of a dispute. Finally, they say that the term case, which you find in the protocol, and the term dispute, which we also find in Article 3.1, they say that these words are to be used interchangeably. They suggest no implication should be drawn from the use of one term or the other. Mr. Vice President, honorable members of the court, each and every one of these arguments is misconceived, and in some cases, they are incomprehensible. Let me address them one by one. First, the idea that the requirement of the existence of a dispute is not one which finds a place in human rights litigation flies in the face of the application of that same requirement to several interstate cases concerning human rights and brought under various human rights treaties. The ICJ considered and restated this requirement of the existence of a dispute in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination between Georgia and the Russian Federation. And in that case, dealing with the Racial Discrimination Convention, the court engaged in a detailed inquiry of whether the two states had been involved in a dispute on that subject matter at the time the case was lodged before it. That's a racial discrimination case. In a case brought under the Convention Against Torture, the ICJ reiterated that jurisdiction hinges upon the existence of a dispute at the time the application was filed. This was a case between Belgium and Senegal regarding the obligation to prosecute or extradite. In fact, in that interstate case, undoubtedly, human rights interstate litigation, it also offers an example of the legal consequence attaching to a lack of a dispute at the time of the submission. The ICJ not only examined whether a dispute existed between the parties regarding the Torture Convention, it also went on to examine whether a dispute extended to breaches of customary international human rights law. The unanimous bench in that case found that there was, at the relevant time, a dispute relating to the Torture Convention, and for that reason found that it had jurisdiction with respect to that dispute. A large majority of judges also held that there was no dispute between those states relating to breaches of obligations under customary international human rights law, and held that the court had no jurisdiction to deal with Belgium's claims in that respect. As the applicant itself has recognized, the ICJ has also applied the requirement on the existence of a dispute in several cases brought under the Genocide Convention. It's done so in 3 recent cases, all of which are referred to in the applicant's own reply brief. The case between South Africa and Israel concerning the application of the Genocide Convention in the Gaza Strip, the case between Ukraine and Russia concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, the case between Gambia and Myanmar concerning the application of the Prevention and Punishment of the Crime of Genocide. All interstate human rights cases, the ICJ applied this requirement that a dispute must exist at the time of submission. Finally, on this point regarding the application to human rights cases, final point here. The DRC is well aware that this requirement of the existence of a dispute also applies in human rights litigation, not merely from all of these other cases, but also from the experience of the DRC itself in prior interstate litigation that it has been involved in relating to human rights. In a case between the same parties as are now before this court, the DRC and Rwanda, the ICJ applied this requirement to a claim that was brought by the DRC in relation to the Convention on the Elimination of Discrimination Against Women, Human Rights Treaty. This is the case concerning armed activities on the territory of the Congo, new application, in which the court found that it lacked jurisdiction, 2006. Mr. Vice President, honorable members of the court, we urge the court to dismiss the submission that this requirement of a dispute does not apply in a case such as this. This requirement follows from the terms of Article 3 of the Protocol, which in turn represents the scope of what the parties to the Protocol have consented to. They have only consented to the jurisdiction of the court in interstate cases insofar as a dispute that actually exists at the time, is submitted to it. The court is bound to respect that consent and thus to respect the jurisdictional limits set out in the protocol. And moreover, there is no reason why the court should depart from the practice of other international courts and tribunals like the ICJ, whose jurisdictional instruments similarly refer to the submission of disputes. The second reason to reject the applicant's arguments as to the existence of a dispute is that it is simply wrong to say that this requirement leads to formalism. As the applicant itself has noted, the ICJ has stated on many occasions, and I quote, "The court's determination of the existence of a dispute is a matter of substance, not form or procedure." There is no formalistic approach to the determination of whether there is a dispute. What is required is an examination of the real state of affairs between the states concerned. A third reason for rejecting the argument that there is no requirement of a dispute is that the applicant confuses the requirements for submitting a communication to the African Commission on Human and People's Rights, with the jurisdictional constraints on this court. They insist that a state is able to submit a communication directly to the Commission against another state without first bringing the matter to the attention of the state that is complained against. They then say it must also be possible before this court. The DRC bases this suggestion on what it describes, and I quote from their reply, it describes as a combined reading of Articles 47, 48, and 49 of the Charter. However, reliance here on the provisions of the Charter dealing with submissions of communications to the Commission is misguided. This court is well aware of the fact that the provisions of the protocol relating to the procedure by which cases are submitted to the court are not the same as the provisions of the Charter relating to the submissions of communications to the Commission. As you have previously stated, and I quote, in the case between the African Commission on Human and People's Rights and Kenya, as you stated, and I quote, "The court is of the view that admissibility and other procedures relating to a complaint before the Commission are not necessarily relevant in determining admissibility of an application before this court." Now, this was said in relation to admissibility, but the court also spoke about other procedures relating to a complaint. And the same thinking applies also to the rules regarding jurisdiction. Simply put, those rules are not exactly the same for the Commission as for the court. Otherwise, the protocol and its carefully delineated language would serve no purpose. In any event, the provisions in Articles 47 to 50 that they rely on, though not directed at the court, they show how the drafters of the Charter did have in mind that before African institutions are engaged by states who are of the view that violations have occurred, that there should be an attempt at friendly settlement of the issue with the allegedly wrongdoing state. Now, although a state may submit a communication to the African Commission without first having communicated the matter to the state, the Commission is then tasked with seeking a friendly settlement, or what the Charter refers to as an amicable solution. So to compare this careful, amicable process with the unilateral filing of a legal dispute before this court is disingenuous. In all matters submitted to the African Commission, there will first have been a process of identifying the dispute, seeking to understand and resolve it in an amicable way before the Commission moves to the merits of the claim. The requirement of the existence of a dispute does no more than provide similar opportunities for the resolution of that dispute prior to the submission to this court. A fourth reason for rejecting the applicant's arguments that there is no requirement of the existence of a dispute at the time the application is filed is that this argument fails to give effect to the actual words of Article 3.1 of the protocol. That provision specifically refers to the submission of cases and disputes to the court. The applicant suggests that the word case and the word disputes, as used in Article 3, are interchangeable, and that the court should not, indeed they say, does not make any distinction between cases brought by individuals and those brought by states. This argument as meaning the same thing as the word case in Article 3.1 is inconsistent with a basic rule of treaty interpretation. This is the principle of effectiveness, the basic rule of international law regarding treaty interpretation. According to this principle of effectiveness, it is not open to the interpreter of a treaty to adopt a meaning which would render the text redundant. Words in a treaty must be given effect to. So when Article 3.1 of the protocol speaks of cases and disputes, the word dispute must be given effect to and cannot simply be interpreted out of the text. The argument of the applicant that case, the word case, and disputes are in this context interchangeable does not stand up to scrutiny because Article 3 uses both. It uses both of these words. It cannot be the case that the drafters meant to speak of the same thing twice. If the two terms are interchangeable, then Article 3.1 is to be interpreted as speaking about the submission of cases and cases, or to be interpreted as speaking of the submission of disputes and disputes. Clearly, the inclusion of the word dispute is intended to add something different in that provision to the word case. For that reason, it cannot be ignored. And we submit that when Article 3.1 speaks of the submission of disputes, that in accordance with the practice of other international tribunals from where this language is borrowed, it specifically covers disputes between states. Mr. Vice President, honorable members of the court, having established that in interstate cases like this one, the court's jurisdiction only extends to the submission of disputes that were in existence at the time of the filing of the application. Let me now turn to the application of that condition in these proceedings. So what does it mean in these proceedings? As was set out by the Permanent Court of International Justice in the famous Mavromatis Palestine concessions case, and has been repeated on many occasions, a dispute between states, and I quote, is a disagreement on a point of law or fact, a conflict of legal views or interests, end quote. We have set out in our written pleadings the key principles that are to be used to identify a relevant dispute between the parties. First, for a dispute to exist, and again I quote from the Mavromatis case, quote, it must be shown that the claim of one party is positively opposed by the other, end quote. It must be shown that the claim of one party is positively opposed by the other, end quote. This reference to the claim of one party being opposed by the other relates specifically to the claims that are later brought before the court. It is not sufficient to show that the parties have disagreements or differences in relation to other matters. For there to have been a relevant dispute, the ICJ has stated, and I quote, the evidence must show that the parties hold clearly opposing views with respect to the issue brought before the court. With respect to the issue brought before the court. Second, again, as the ICJ has held, a dispute exists, I quote, a dispute exists when it is demonstrated on the basis of the evidence that the respondent state was aware or could not have been unaware that its views were positively opposed by the applicant. Okay, so the respondent state must have been aware or could not have been unaware that its views were positively opposed by the applicant. This means that for there to be a dispute, the applicant must have set out its claim clearly. In other words, the applicant must have made claims which allowed the respondent to understand that the applicant was of the view that the respondent is in violation of legal rights which form the basis of the action, the legal action that is now before the court. Third, while evidence of a dispute can be gleaned from statements that are made by state officials, the court must give particular attention to the content of those particular statements. In particular, a statement will only be said to have given rise to a dispute, or will only be evidence of a dispute, if it refers to the subject matter of a claim, and again I quote from the ICJ, if it refers to the subject matter of a claim, and I quote, with sufficient clarity to enable the state against which that claim is made to identify that there is or may be a dispute with regard to the subject matter. So the statement must refer to the subject matter of the claim with sufficient clarity to enable the state against which the claim is made to identify that there is or may be a dispute with regard to an alleged breach by the respondent of the particular obligation or right that is put in issue between the parties in the judicial proceedings. Fourth, the respondent must have had the opportunity to address the particular claim that is made by the applicant. there will only be a dispute where either the claim of a violation of legal right is positively opposed, in other words, it's rejected by the respondent, or the respondent state fails to reply to the applicant's claim of legal violation. Now, judged against all of these principles, it is manifest that there was no dispute between the parties to this case concerning the claims that properly form the subject matter brought before this court. So there was no dispute between these parties concerning the claims that are now brought before this court. The factual record, even as presented by the applicants, reveal that there was no relevant dispute at the time the DRC filed its application. When we say that there was no relevant dispute, what we mean is that at the time when the application was lodged, there was no dispute between the DRC and Rwanda regarding the human rights matters, the human rights claims that fall within the present application. Now, the applicant has tried to overwhelm the court by submitting a multitude of statements and documents which are wholly irrelevant to the issues that properly form the subject of a human rights claim before the court. It has submitted all manner of allegations of supposed wrongdoing by the respondent in order to persuade the court that there was a dispute at the time it filed the application. But what is required is not a suggestion that the parties might have had any type of difference. It has to be shown that the issues that properly form the subject matter of this claim, this case, those issues were in dispute. It has to be shown that there was a disagreement regarding the alleged human rights violations that this court is able to deal with. Now, the applicant has submitted a number of statements in which it accused the respondent of aggression and of unlawfully using force within its territory. It then suggests that those statements in this regard and their opposition by Rwanda constituted a dispute before the application was filed. But this approach and the documents submitted reveal very clearly that there was no dispute between the parties regarding the subject matter within the jurisdiction of the court, violations or alleged violations of human rights. As the court will have noted, the DRC did not, in those documents that it submitted, those documents predating the filing of the application, in those documents it did not allege violations of human rights. They alleged aggression. They alleged unlawful use of force. What those documents show is that the DRC's application is really an attempt to bring matters concerning peace and security before this court. As we will show tomorrow in our presentation on admissibility, this attempt to mischaracterize matters relating to use of force and maintenance of peace and security as within the competence of the court, it permeates the case throughout. And it makes this case inadmissible for several reasons that we will discuss tomorrow. Moreover, as I will show very shortly, claims under the UN Charter, the Charter of the United Nations, under the African Union Constitutive Act, fall outside the jurisdiction of this court, as they are not human rights instruments as set out in Article 3 of the protocol which defines your jurisdiction. But for now, let us look at the statements that the DRC cites in its reply brief as demonstrating the existence of a dispute between the parties. First, there is the statement of the President of the DRC, made in the United Nations General Assembly on the 20th of September 2022. They rely on it in their reply brief. He accused Rwanda of making direct incursions into the territory of the DRC and of engaging in occupation. But he did not make any claims of the violations of human rights, the type of violations that this court can actually deal with. True, the President of the DRC referred to the United Nations Charter, he referred to the African Union Constitutive Act, but as I will show shortly, these are not human rights instruments within the meaning of Article 3. There is therefore nothing in that statement that would enable the respondent to know that there was a human rights dispute regarding matters that are now brought before this court. Rather, what was being alleged there was an act of aggression, an allegation that, beside being thoroughly contested, does not fall within the jurisdiction of this honorable court. The DRC further contends that on the 19th of November 2022, that at the 18th summit of the Organisation Internationale de la Francophonie, that its prime minister refused to take a family photo in protest against human rights violations by Rwanda. First, there is no evidence that is given of any particular reasons that were offered at the time by the Prime Minister for refusing to take the photo. Also, it is hard to see how this act of declining to take a photo could possibly fit within the ICJ's jurisprudence that a statement only gives rise to a dispute when it is sufficiently clear in referring to a dispute about the specific subject matter brought to the court. Likewise, in the statement of the DRC's permanent representative to the United Nations, made before the UN Security Council on the 29th of March, 2003, there was no mention made of human rights or of any treaties that this court has jurisdiction to apply. Again, the chief leitmotif of these statements is the allegation that Rwanda has committed aggression. But that is not a human rights claim that is justiciable before this court. That is another matter, and that is not the dispute that is submitted to this court. Mr. Vice President, you may be relieved to know, honorable members of the court, we don't have time to go through all the statements that the DRC refers to in its reply. But when you look at them individually and you take them as a whole, a few things emerge. They do not refer to the human rights treaties that are properly within the jurisdiction of the court. They do not even refer to human rights. The DRC has now, in its reply, adopted commentary that liberally asserts violations of human rights. But the statements themselves do not say so. The statements accuse Rwanda of using force, supporting the use of force, undermining the DRC's territorial integrity, but that is not a human right. dispute. Those are not human rights violations. On occasion, these statements make allegations about specific incidents that they allege has led to loss of life. But again, there is nothing that indicates with clarity that these claims are distinct from the usual allegations of violations of territorial integrity or sovereignty, or even an indication that those allegations of loss of life arise from human rights violations. So to conclude, on this first aspect of the jurisdictional objection dealing with material jurisdiction, Rwanda submits that it is a condition of the court's jurisdiction in interstate cases that a dispute about human rights must have existed at the time when the application was submitted to the court. And in our submission, it is very clear that at the time this application was filed, even if there were some differences between the DRC and Rwanda on other matters, it cannot be shown that there was a dispute relating to the human rights treaties or human rights violations that form the basis of the court's jurisdiction. Mr. Vice President, honorable members of the court, let me now turn to the second argument that we have regarding lack of material jurisdiction. That's the argument that aspects of this case fall outside of the material jurisdiction of the court because the applicant relies in part on documents that are not human rights instruments ratified by the respondent. With your indulgence, let me again quote from Article 3, Paragraph 1 of the protocol. I quote again: "The jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation of the Charter, this protocol, and any other human rights instrument ratified by the states concerned." And any other human rights instrument, any other relevant human rights instrument ratified by the states concerned. This provision is crystal clear. The court has jurisdiction to entertain claims brought not only under the African Charter and Protocol, but also under other instruments, as long as two conditions are met. One, those instruments must be relevant human rights instruments. Two, those instruments must be ratified by the state concerned. which Rwanda accepts falls within our those instruments. The DRC also includes violations of the United Nations Charter, the Constitutive Act of the African Union, the Pact on Security, Stability, Development in the Great Lakes region, the Peace, Security, and Cooperation Framework Agreement for the Democratic Republic of Congo and the region. Now, I note that in the application that was originally filed by the DRC, those instruments were referred to, but the DRC did not make it clear that it was alleging a violation of those instruments. However, in its reply brief, the DRC clarifies that it was indeed alleging a violation of these instruments. Rwanda submits that the court does not have jurisdiction to deal with alleged violations of the 4 instruments I have just mentioned. This is because, 1, they're not human rights instruments. In the case of the Great Lakes Pact, and in the case of the Peace, Security, and Cooperation Framework, they are not instruments ratified by Rwanda or indeed by any other state because they are not treaties. To make a definitive finding that these instruments, these 4 instruments, fall under the jurisdiction of the court. It also alleged that some of this conduct also violates the African Charter or other human rights treaties. As a general matter, the jurisdiction of the court is defined by the consent that states have given. And the court should, and indeed must always, be careful to ensure that it is sticking to the competence it has been given. States have only given the court a mandate to deal with violations of human rights instruments that are binding because they have been ratified. No more than that. In this specific matter, the DRC tries to muddy the waters by mixing matters relating to peace and security with human rights claims. This is a human rights court that is tasked with dealing with violations of human rights. The applicant does not hide its intention to draw this court into deciding on matters relating to the use of force. It says very clearly in its reply, and I quote, "There is an inextricable link between human rights and the use of force, peace, and security. The use of force by one state, Rwanda, against another state, the DRC, as in the present case between these 2 states, has a negative impact on human rights in that it generally leads to the violations of these rights." End quote. In other words, the applicant is suggesting that whenever there are this court will automatically have jurisdiction to deal with such a case under the guise that this is a matter concerning human rights. Nothing will bring this court into greater disrepute than this sort of argument. And such an attempt to broaden the jurisdiction of the court beyond the mandate that it has been given must be rejected. The other point that is of relevance here is that by insisting that the court has jurisdiction to deal with claims under the UN Charter and the AU Constitutive Act and other peace and security instruments, the DRC seeks to claim that the matters it now brings to the court are the matters that were already in dispute between the parties at the time when it filed its claims. As I showed you, the DRC made reference to a number of statements in which it claimed that Rwanda was using force on its territory, allegedly in violation of the UN Charter and the AU Constitutive Act. In arguing that these are issues within the jurisdiction of the court, the applicant is trying to show that there was some continuity between the issues that were raised in those statements and matters that are now within the jurisdiction of the court. If the court were to confirm that alleged violations of the UN Charter, the AU Constitutive Act, and other instruments relating to peace and security do not fall within the jurisdiction of this court, this would also confirm that there was, in fact, no dispute between the parties relating to human rights prior to the filing of the application. Let me now turn to the two conditions that I referred to in relation to these instruments. The test for ascertaining whether an instrument is a human rights instrument is fairly simple, and it has not been particularly contentious. This court has been very clear as to whether it considers an instrument to be a human rights instrument. You stated in one of your previous cases, Action pour la protection des droits de l'homme against Côte d'Ivoire, you stated, and I quote, "In determining whether a convention is a human rights instrument, it is necessary to refer, in particular, to the purposes of such convention. Such purposes are reflected either by an express enunciation of the subjective rights of individuals or groups of individuals, or by mandatory obligations on states parties for the consequent enjoyment of human rights, of the said rights, sorry. I repeat, such purposes are reflected either by an express enunciation of the subjective rights of individuals or groups of individuals, or by mandatory obligations on states parties for the consequent enjoyment of the said rights." The key requirements here are very clear. There has to be an express enunciation of the human rights in question in that instrument, or obligations have to be imposed on states with regard to the said rights, the particular rights that are in issue. The DRC makes an issue of the translation of this passage that I have just quoted. And they argue that it has a slightly different meaning in the French translation. The DRC argues that the French version of this judgment shows that the instrument does not need to set out binding obligations. However, in making this argument, it has left out relevant wording that undermines its argument. The relevant paragraph from that judgment does not simply state that the obligations in question are, and permit my with your indulgence, I'll use my very poor French. So the judgment does not really state that the obligations in questions are obligations impliquant la jouissance, as stated by the applicant. Rather, this judgment referred to la prescription à l'égard d'État. So the stipulation of obligations regarding states that involve the consequent enjoyment of human rights. In short, the instrument must provide for binding obligations with regard to human rights. Now, we do not argue that a treaty is only a human rights instrument if it exclusively deals with human rights. However, we do say that when the court speaks of an express enunciation of subjective rights of the individual, it does require that specific rights are set out in the instrument. Although the UN Charter and the AU Constitutive Act refer to the promotion and the protection of human rights when listing the aims of those organizations, neither instrument actually sets out specific rights. They do not include an express enunciation of such rights, nor do they provide obligations regarding the enjoyment of any particular rights. The applicant suggests in its reply that the court has held that the Constitutive Act of the AU and the UN Charter are human rights instruments because the court has referred to such instruments in its judgment. With regard to the AU Constitutive Act, the applicant refers to the judgment of this court in the Mohammed Abubakari versus United Republic of Tanzania case, where it is true that the court did in fact make reference to the Constitutive Act of the AU. However, that case in no way supports the applicant's position. The issue in that case was whether the application was admissible. And what the court was considering was whether the provisions in what is now Article 50, Paragraph 2b of the rules of the court on admissibility had been complied with. One of those conditions in Article 50, 2b, in fact, a condition that Rwanda has invoked in this very case, and which my colleague will elaborate on tomorrow, is that the application must be compatible with the Constitutive Act of the AU. In other words, the rules require that the application must not violate the Constitutive Act. Let us be clear what this requirement means. It is the application that must not violate the Constitutive Act. It is not that the court is to examine whether the conduct of the respondent is a human rights violation of the Constitutive Act. In fact, in the Mohammed Abubakari case, it had been argued that the application was inadmissible because the applicant had not alleged breaches of human rights in violation of the Constitutive Act. It was in response to that argument that the court explained that the provisions of the rules, which say that the application must not be incompatible with the Constitutive Act, does not render, or in that particular case, did not render an application inadmissible because it did not allege that the conduct of the respondent violates the Act. It was in that context that this court stated, and this is what's important, and I quote, it's in that context that this court stated, I quote, "The violations alleged in the application are susceptible to be examined by reference to the Constitutive Act and or the Charter, and are not manifestly outside the scope of application of those instruments." In other words, examinations of the violations of the human rights instruments must not be debarred by some incompatibility with the Constitutive Act. That was the point. So there's nothing in that case that suggests that the Constitutive Act is a human rights instrument. Let me now turn to the UN Charter and whether it is correct to say, as the DRC does, that this is a human rights instrument within the meaning of Article 3 of the Protocol. It's true that members of the UN in Articles 55 and 56 of the Charter pledge to take action in cooperation with the United Nations Organization for the achievement of respecting human rights and fundamental freedoms. However, the Charter does not anywhere specify any particular human rights, meaning that the express enunciation of rights that this court has said is the standard for a human rights instrument is absent. Furthermore, it is hard to say that Article 55 and 56 specify clear obligations with respect to human rights, such as this court would expect from a human rights instrument. In exactly the same provision, members of the UN also pledge to take action to achieve full employment, higher standards of living, solutions of international economic and social problems. But we do not then say that there is a violation of the UN Charter when these lofty goals are not achieved. The applicant, in its reply brief, suggests that this court has found that the UN Charter is a human rights instrument. They refer to the case of Frank David Omari and Tanzania. However, this is incorrect, as the applicant, again, misunderstands the court's reference to the UN Charter in that judgment. In that case, what the court actually said was, and I quote, "In fact, Article 60 of the African Charter authorizes the court to draw inspiration from international law relating to human and people's rights, in particular from various African human rights instruments, the United Nations Charter, the Constitutive Act of the the Charter of the Organization of African Unity, and the Universal Declaration of Human Rights." To understand what the court was saying in that case, it is important to note that Article 60 of the African Charter is actually directed at the Commission. It is the Commission which has a different mandate that is specifically directed to draw inspiration from those materials. Now, this is important because though the court says that it may draw inspiration from those materials, it is clear that the court can only draw inspiration from those materials once it is established that it has jurisdiction. And the court's jurisdiction is only established after it is determined that the application is based on a human right instrument ratified by the state concerned. In fact, it's very clear that in that case, the Omari case, the court was not using those materials to define what is a human rights instrument. Very clear, because the court in that case lists the Universal Declaration of Human Rights, and then the court clearly says that the Universal Declaration of Human Rights is not one of the human rights instruments that fall within Article 3 of the protocol. So all the court was saying is that once jurisdiction is established, it can draw inspiration from international human rights law, for example, to interpret the instruments that are in fact within its jurisdiction. In summary, there is nothing in the court's case law that deviates from the starting point, that in determining whether a particular treaty is a human rights instrument within the jurisdiction of the court, that treaty has to contain an express enunciation of the human rights in question. The Constitutive Act of the AU, the United Nations Charter, do not do so, and thus they are not human rights instruments within the meaning of Article 3. Mr. Vice President, honorable members of the court, let me now briefly turn to my final point. And this is the second reason why some of the instruments relied on by the applicant fall outside the material jurisdiction of the court. This is the requirement that not only must the instruments be a human rights instrument, it must be one that is ratified by the states concerned. In other words, the court only has jurisdiction to consider violations of treaties that the respondent state has become party to. Only treaties are ratified by states. The drafters of the protocol chose their words carefully. The purpose of this requirement is only to include within the material jurisdiction of the court allegations of violations of instruments that are explicitly ratified by the respondent. The DRC seeks to found the jurisdiction of this court, in part, on the Pact on Security, Stability, and Development in the Great Lakes region, and on the Peace, Security, and Cooperation Framework Agreement for the Democratic Republic of Congo and the region. However, these are not treaties ratified by states, and certainly not by Rwanda. Thus, even if they were to be regarded as human rights instruments, the characterization that Rwanda disputes, for the reasons I have set out, they fall outside the material scope of the court's jurisdiction. Despite this very clear text, and indeed it could not be clearer, we were very surprised to read in the applicant's reply brief the suggestion that this court's case law says the opposite of what the protocol provides for. The DRC says that it is not essential for every human rights instrument to have been ratified in order to establish the court's substantive jurisdiction. I'm sure that this will come as a surprise to the court too. To justify its claims that the court has jurisdiction over alleged violations of instruments not ratified by the states concerned, the applicant refers to cases where it says the court has applied the Universal Declaration of Human Rights. The Universal Declaration of Human Rights, it's not a treaty. It has been referred to by the court, but the court has been clear, crystal clear, that the Universal Declaration is not a human rights instrument that falls within Article 3. Reference was made by the applicant to the Frank David Omari case that I've just referred to, Frank David Omari and Tanzania. There, this court ruled in paragraph 74 of your judgment that reference to the Universal Declaration is permissible, and I quote, as long as the alleged violation is also provided for by a treaty ratified by the state concerned. This court, end quote, end quote. This court then went on to state, in the very next sentence, as if for the avoidance of any doubt, this court then stated, quote, the court has the power to exercise its jurisdiction over alleged violations in relation to the relevant human rights protection instruments ratified by the respondent, end quote. So not only is the text of Article 3 of the protocol very clear, the case law of this court is also clear. For the court to have jurisdiction, the instrument must have been ratified by the respondent. For this reason, we submit that allegations of violations of instruments that are not treaties fall outside the material jurisdiction of the court. Mr. Vice President, honorable members of the court, with your indulgence, let me bring my presentation to an end by repeating Rwanda's submissions that the application must be dismissed because, one, the case falls outside the territorial jurisdiction of the court, and two, because the case does not fall within the material jurisdiction of this court. Honorable members of the court, this concludes Rwanda's presentation on jurisdiction this morning. I'm very grateful to you for your kind attention.
Merci pour les exceptions soulevées. À présent, nous allons observer une pause d'1 heure de temps. Au retour, il y aura l'État requérant qui va plaider en réplique sur les exceptions d'incompétence.
To present its objections regarding jurisdiction. Thank you very much.
thank you for your kind attention, and kindly give the floor to Professor Kulamba, who will come to express the facts in this case.
President, honorable judges, I thank you for giving me the floor. About over 25 years ago, the last century, at least its last decade, I had the opportunity of being part of the team that came to make a submission against 3 of our neighbors, more specifically, including Rwanda, before the African Commission on Human and People's Rights. Subsequently, Minister of Human Rights, I followed up the procedure at the Commission till its conclusion, where a decision was rendered that has become a jurisprudence today. Today, I have the honor, after about 30 years, to come back to your court, the highest instance of promotion and protection of human rights in Africa. The observations are painful. There have been no progress over the years. Human rights violations have been exacerbated, diversified with barbarism. Rwanda is stepping over all provisions on human rights for women and the child, and more specifically, DRC accuses Rwanda of, through the feds and the inhuman acts that they have committed on Rwanda territories, allowing itself to do anything it wished. It committed several serious and massive violation of human rights protected by the African Charter on Human and People's Rights and other instruments ratified by the 2 states, while advancing the same pretext, repetitive narrative, arrogance against international and African opinion, an absence of accountability, and with a guaranteed impunity. It is rightly that the African Charter on Human and People's Rights thought it proper to conventionalize the right of people to peace, which is royally disregarded by RDF. The flagrant violation of these rights have been translated into a real aggression and territorial occupation of the DRC, led to a bellicose fury in the human rights space, where the rights to peace and human and dignity of life are guaranteed. The Vice President has said that this is the first of human rights, the right to moral integrity, the prevention of degrading treatment, peace and personal security, the right to education, the right to property, the right to housing, the right to enjoy a better state of physical and mental health, the right to the protection of family, women, the child, and senior citizens, the right to food, which is disregarded in the Goma town where the refugees are displaced, the right to development, the right to environment, the right to effective recourse to justice for reparation, the right to sovereignty. In fact, and looking closely, all these gratuitous violation of human rights, of the rights of Congolese, are part and parcel of a genocidal plan, properly thought out, well structured, surreptitiously and maliciously covered by security pretexts. Violations are also grounded on a policy of predation and on the resources of Democratic Republic of Congo. At this stage, we have to talk about the preliminary objections, but the violation of human rights needs to be contextualized, and I'll do that in 4 dimensions. Honorable Vice President, honorable judges, it is a notorious fact that a great number of Rwandan Defense Forces from the Special Forces have invaded the eastern part of the Democratic Republic of Congo since 2021 and have been operating there, sometimes on their own, sometimes in support of terrorist armed groups. The facts that underpin this situation is armed conflict opposing the armed forces of Rwanda and the terrorists of M23, supported in weapons on one hand by Rwanda, to the armed forces of Democratic Republic of Congo, supported by volunteers of defense of the fatherland. This armed conflict was intensified in a dramatic manner, such that it has affected 2 provinces in the eastern part of DRC, North Kivu and South Kivu, affected in various places, and many territories have been impacted by Rwanda and M23. The list is very long. Unagana, Jomba, Usuru, Chuanja, Rumangabu, Kisigari, Urugari, Mumba, Nyiragongo, Kayabayonga, Kishishe, Kichanga, Kididi, Masitani, Kanambi, Nyabibwe, and currently the very town of Goma. According to the UN report 25th December 2024, Rwanda has at least 3,000 to 4,000 troops on the Rwandan, the Congolese territory. The number has significantly increased so as to facilitate the invasion and takeover of Goma on 26 January 2025. And many reports, official reports from UN experts and other international organizations, Human Rights Watch, International Red Cross, and so on and so forth. And they have the evidence, and among the documented evidence, the report brings other evidence, including photographic and documentary evidence and aerial images of military operations conducted by soldiers in RDF military uniform in the Nyagongo territories in between November 2022 and March 2023. There were military intelligence officers captured, soldiers captured. The evidence, we have multiple evidence, and at the appropriate time we will have the opportunity to serve it. More recently, in a report distributed in June 2024, and the FAIR group re-emphasizes the same facts and gives evidence of the presence of Rwandan forces, particularly the special forces on the Congolese territory, and who have conquered many localities. As you do know, the Security Council reiterated the condemnation of the military invasion of DRC by the RDF and in support of M23. It's in this context that Rwanda has carried out many acts that constitute violation of human rights, for which reason the DRC has come before this court. These are facts of extreme gravity, denounces limitless barbarism, total disregard for the humanity with genocide intentions for an ethnic cleansing intended or targeted again identifiable and ethnic groups. We observe that the Rwandan Defense Forces continue their acts in Congo.
Increase your voice.
DRC drew attention of the court to the fact that the ongoing armed conflict is a cause of a serious humanitarian gravity with deplorable consequences and injustice suffering for the population living there. More than 2.4 million internally displaced persons for only the North Kivu province, and to this must be added the 300,000 displaced persons in the outskirts of the Goma city. The internally displaced persons are subject to inhuman living conditions and slow programmed death. The propagation of HIV/AIDS and diseases having affected the displaced person of the Kanyarushunga and Mungunga by Rwanda and M23. Children enrolled forcefully. The looting of resources, destruction of infrastructure, of interests such as hospitals, schools, electrical generating facilities, and cultural facilities. There are many reports, and these have already been communicated as annexes to our pleadings. So I'll move on to the third point, the reasoning. The main reason of the armed intervention of the RDF on Congolese territory is ethnic cleansing of a certain group, the Hutu, particularly the Hutus, the Undes, as well as the Congolese population. This looting of natural resources, which is purely genocidal act. The genocidal ideology is visible but maliciously covered. The Rwandan authorities regularly use disparaging terms in reference to the Congolese population, particularly certain target ethnic groups, so as to ensure their extermination or diminution. In Kenya, Rwanda, they refer to them as follows. They refer to them with the term Ibichuchu, meaning idiot, a less intelligent person. It is also the looting of resources, because if you look at the cartography, the mapping of conquest, on the mapping of natural resources of the Congolese territory, you see that both these maps coincide. And that is the case, for example, of Rubaya. You know that at Rubaya, M23 draws a profit of $800,000 per month, enabling them to support the war efforts and to continue their conquests with the support of the Rwandan armed forces, as well as the minerals. The new roads are being built. Finally, Honorable President, honorable judges, it is urgent to do the needful to correct the situation before it gets too late. Looking at the ongoing events on the DRC territory, you yourselves have followed what happened during the bloody takeover of the Goma town, 26-27 January 2025. 294 wounded persons. We are today at 3,000. Summary executions. Human rights defenders chased out. Many corpses decomposing across the town, threatening epidemics, rape cases, including children, forcibly displaced persons. More than 700,000 are displaced. Rwanda has announced on 29th January 2023 that it will continue its territorial conquests to the town of Bukavu, and we should expect the very worst. Honorable Vice President, honorable judges, DRC would like to appeal to you to safeguard the values of Lubuntu through your sacred duty, your sacred mission, noble mission of guardians of human and people's rights in Africa. Your vision intends to disseminate values of human rights across Africa. Through Africa, that also means in interstate relations. DRC is of the view that the time has come for the court to use its jurisdiction to bring Rwanda to reason and respect of law, scrupulous respect of human rights, not only for Rwanda, but also for neighboring countries. Honorable Vice President, honorable judges, your mission is a noble one. And Congo, coming here before you for the second time, has a lot of confidence in you, and eyes of citizens of DRC, men, women, children, widows, are looking at you. Thank you.
President, honorable judges, it is an honor for me to stand before you today, and I would like to prove the material jurisdiction of this court. To that end, I'll be speaking to 4 issues. 1, and to begin, it is undeniable and clear that your material jurisdiction is based on the violations on human and people's rights committed by Rwanda some which were criticized in this application. Rwanda repeats again under Article 3. You heard it this morning of the Ouagadougou Protocol. This claims that this court lacks material jurisdiction to hear the issues raised in the application. To support its reasoning, it refers to a matter between states, and that matters between states should be limited to the conflict between these states at the time of the filing of the application. The applicant, for its part, affirms that the material jurisdiction of this court is established to deal with this matter. Similarly, you have the mission to interpret and apply the African Charter on Human and People's Rights, the protocol, and any other relevant human rights instrument ratified by the states concerned. Mr. Vice President, honorable judges, the Democratic Republic of Congo filed an application before you claiming that Rwanda violated principally Article 1, 4, 5, 6, 7, 14, 17, 18, 22, 23, 24 of the African Charter on Human and People's Rights. Articles 3, 4, 10, 11, 12, 15, 18, and 19 of the Protocol to the African Charter on Human and People's Rights on the rights of women, Articles 5 and 11 of the African Charter on the rights and welfare of the child, Articles 2, 6, 7, 8, 9, 10, and 12 of the International Covenant on Civil and Political Rights, Articles 12 and 13 of the International Covenant on Social and Economic Rights. Your court, your abundant jurisprudence in this area reveals that your rational material jurisdiction is established once human rights violations which are referred to are guaranteed by the Charter or any other relevant human rights instrument. You have stated to every respondent state which has tried to go away from this, just as is the case in this matter, you've stated in very clear and significant manner. So, by way of example, let's take a few words from the judgment in the matter of Peter Joseph Chacha versus the Republic of Tanzania. In this matter, it was determined, and I quote, as long as the rights which are alleged fall under the Charter or any other relevant human rights instrument ratified by the state concerned, this court will exercise its jurisdiction in the matter. End of quotation. Many separate opinions and individual opinions have gone along the same lines, and that is the case of Judge Blaise Chikaya in the matter of Uchechura versus Tanzania, where it stated, and I quote, the court has invariably considered, as a matter of fact, that where for it to have jurisdiction, it just suffices that the right whose allegation is referred to is under the Charter and ratified by the state concerned. As you must have seen through the submissions of the other party before this afternoon, Rwanda does not challenge the fact that human rights which are alleged by the DRC are protected under the Charter and other relevant human rights instruments which have been referred to in the application. This said, we believe that continue to discuss on this issue, and which is poorly used by Rwanda, can only embarrass and waste time on instead of talking about issues of human rights. Mr. Vice President, honorable judges, secondly, Rwanda's strategy, which consists in hiding behind the reality, it even made reference to the Vienna Convention on the Rule of Law of Trade. For fact, Article 31 of the Vienna Convention on Treaties, referred to by Rwanda in its defense, is very much in favor of the systemic approach. This method of interpretation guarantees that the provisions of the protocol do not produce effects in an isolated manner. They have to be interpreted and applied in a body of legal systems in force at the time when the interpretation is taking place. This approach, through Article 31 of the Geneva Convention, referred to that in this case, it should be an intrinsic fact which is inherent in this article, but we should look for other possible cases, and we should not limit ourselves to this case. If Rwanda invites you to carry out a systematic approach of the protocol, it is simply because it is the most appropriate way of determining continue to persist following this approach, and that is why with such a demonstration it preferred to assimilate the situation between the African Court on Human and People's Rights and the International Court of Justice. Let us try to imagine that the approach which govern practice in these courts cannot be exactly the same in both institutions, because they lack legal basis. Rwanda's argument should simply be dismissed in block. The respondent insists on the conjunction a, that's an in French, to give this word a meaning which is not accepted in this case. By referring to this conjunction a, which means an in English, Rwanda gives the impression that it does not know that in the same provision of Article 3(1) of the protocol, the conjunction a or an has been used 4 times in this same article. The fact is, from the syntagmatic point of view, without being redundant or lack of meaning, the several use of this conjunction an or a plays the role of a coordinating conjunction. It does not express in the proper sense a simple addition when we say an, but the first enumeration of the conjunction and between matters and conflicts which are from the same level of syntax coordinate and unify 2 terms whose semantic meaning cannot be distinguished. It would have been the same if the article used a comma before the word and if it had been written in this manner, I quote, "The court has jurisdiction to hear all cases, comma, and all matters or conflicts." The meaning would not have been very different. If the court wanted to make a semantic difference, it would have put a comma before the word and, but that's not the case here. And it would have been different also if we found repetition of the conjunction and to show a difference between the terms which have been enumerated. There, in a similar case, therefore, we could say that there's a difference in meaning between the 2 terms, notably if the provision was stated as follows, and I quote once again, "The court has jurisdiction to hear and all the cases, comma, and all the conflicts," end of quote. The "and" in this case would have had the status of an additional conjunction which would have given specific meaning for each term enumerated. But unfortunately, this is not the case. In any case, the shortness of Rwandan reason emerges when we come to the other uses of the same conjunction "and", which is used after the same provision under Article 3(1). So, we become aware, for instance, the second use of "and" which exists between the terms interpretation and application plays the cumulative role of the fact that these two terms fall under the purview of a reasoning where they are linked, and we can even say they are integrated. So the mission of this court does not only consist in interpreting but also in applying. To apply an instrument, you should first of all have the meaning within the purview of a human rights case. Before this court, the application which they do of the Charter, the protocol, and other relevant human rights instruments is as a result of interpretation. The third level of meaning of conjunction, of the conjunction "and" in the provision of Article 3(1) is preceded by a comma. And here, the conjunction "and" comes after the enumeration of the Charter and the protocol. And here, there's an additional conjunction which is different from the first enumeration of the expression different and case, or matter and case. The third conjunction "and" plays the role of biconditionality because it is required to express a condition which is necessary and sufficient. In other terms, it does not suffice for any other relevant human rights instrument to exist. There's also the condition of being ratified by the states concerned for this court to have jurisdiction to interpret and apply it. This means that the court will have jurisdiction if and only if all other relevant human rights instruments have been ratified by the states concerned. In all, following every logic, the DRC considers that every good interpretation cannot admit that the term "différent" and "affaire" before this court should be used indistinctively to refer to the word conflict, an ordinary conflict between two parties before the court, where one is an individual or a state alleges the violation of human rights claimed to have been committed by the other or a state, where the first holds the second as being responsible. The jurisprudence of this court is indeed a reference which we cannot set aside, and it is a testimony of the fact that the court alternatively uses the term "différent" or the term "affaire" for individual cases, just as it does for interstate cases. Significantly, therefore, it should be noted that it is not by chance that this court, in its order of 7th March 2024, rendered in this case referred only to the word "affaire," and Rwanda cannot claim that the judges of this court did not know that this conflict was between two states. So, if the term "différent" had a particular meaning in the system of the court in interstate contentious matters, why did the court prevent itself from using that word? And even more, if the court preferred to use the word "affaire" with regard to the instant case in its ruling, whereas it had the two concepts before it, by virtue of which, so why should Rwanda substitute the word "affaire" and the word "différent," whereas they are all referring to cases? This becomes even more legitimate when we consider the fact that even in the hypothesis of individual cases, the court follows the same logic. The proof is that the matter Subi Gore and others versus the Republic of Cote d'Ivoire is indeed an excellent example. In this matter, the court explicitly stated, and I quote, that the protocol does not make any distinction between cases or matters that are tabled before the court as long as this conflict concerns the application and interpretation of all the instruments under Article 3 of the protocol, end of quote. Honorable judges, it is important to note that the court even goes further in the explanation of the meaning of words. In fact, it uses, in the place of the coordinating the conjunction, and it uses another coordinating conjunction where in its cases, and this is not by accident. So they seem to be an equivalent in use, and they could be alternatives. And this means that the concepts affaire and différent are identical. They refer to cases or matters or conflicts, and therefore they can be used indistinctively in an individual case, such as in interstate cases. To that end, this court will simply dismiss the argument of Rwanda in challenging its material jurisdiction. Mr. Vice President, honorable judges, fourthly, I want to say that in bid as it may, the evidence of differences between Rwanda and the DRC are many. Rwanda would like to pretend that even if we consider the hypothesis that the court should consider that the existence of a difference or a conflict could affect its jurisprudence, the DRC of the position that there are lots of differences between Rwanda and DRC. Let me use this opportunity to say that the existence of a conflict between Rwanda and DRC are many, and Rwanda comes up with the illusion on this aspect. The DRC has presented through its submissions several points which establish unequivocally conflicts which exist between the two parties at the time when this court was seized of the application. And it was contained in the submissions, and the submissions which have been given before you have demonstrated the continuous nature of these flagrant violations of human rights which Rwanda is trying to challenge, at times implicitly, at times explicitly. The last episode has just taken place last week in Geneva in the Human Rights Council of the United Nations, which under point 1.3 of its resolution condemns very strongly all the human rights violations, strongly condemns the military and logistic support of the Rwandan Defense Forces to the M23 Defense Forces, calls on Rwandan forces to bring to an end their violations of human rights. End of quotation. Honorable judges, when a resolution like this of the Human Rights Council uses terms such as condemns very strongly, calls on, it is not optional. And in any case, from the point of view of the DRC and Rwanda, on the violation of human rights, where the first holds the second, has been responsible and expressed in several ways and on several occasions, they are manifestly opposed. By way of illustration, would like to state the following facts. One, the Rwanda is playing the role of the ostrich. The DRC is blaming Rwanda of attacking its territory by using M3, which carries out several violations of human rights. That's a strategy which it has carried out for several years by fabricating these two rebellious forces which it controls, CNDP, M23, etc. For its part, Rwanda denies categorically by claiming that the conflict between the M23 and the government of Congo is a domestic problem, and that Rwanda should not be taken as a scapegoat or be assimilated to M23. However, while Kigali blames Kinshasa of cohabitating a group which was in charge of the case in Rwanda, on the 14th of 2022, a UN representative wrote to the Security Council where a letter of the Minister of Foreign Affairs of DRC was annexed, and it stated clearly that there were accusations of human rights violations committed on the 10th of June 2022 at 2:15 by Rwandan forces in Giruma and Kabaya, situated in the Kisigari region in Buisha in Rutu region. On that day, scores of bombs were fired through long-range cannons from Rwanda, and it led to human and material destruction. The destruction of a school, Institut Saint-Gilbert, the death of 2 children, Shaka Mapenzi and Jeremy Evumbiza, and they were both 7 and 6 years old. The Congolese minister would like to recall that 2 soldiers of the Rwandan Defense Forces were captured on the 28th of May 2022 by the Congolese Defense Forces with the support of the local population. On that occasion, the Congolese government called on the council to deal with this letter, calling on it to circulate it as an official document of the Security Council. As in reaction, Rwanda dismissed categorically all the accusations made by the DRC on the bombings on its territory. And with regard to its soldiers who were captured, the government of Kigali stated that the 2 soldiers of the Rwandan Defense Forces were kidnapped on the 28th of May 2022 by a joint force, FADC and FDL, whereas these soldiers were patrolling the borders between the DRC and Rwanda. Thirdly, and just by indication, during the meeting of the Security Council on the 9th of December 2022, the Congolese Minister of Foreign Affairs clearly underscored the responsibility of Rwanda in the massacre of Congolese population on the 28th and 29th of November 2022 at Kishishe and Bambo in Hutu territory. Mr. Vice President, honorable judges, the tragedy of that day, which should be called the Kishishe genocide, was indeed particularly cruel, because it was planned and it led to the massacre, systematic massacre of the population. And if we look at this situation, even people who were sick in hospital were killed. People were hiding in schools and in churches were killed. Rwanda expressed, in accordance with its traditional rhetoric, a categorical denial of these accusations. In a communique published on the 22nd of December 2022, they protested in these words, I quote, "Trying to deal with complex situations by repeating and applying false accusations of the government of the DRC cannot lead to a sustainable solution. Notably, the mediatization of the massacres of Kishishe, which is fabricated by the government of the DRC, which it attributed to M23, and without any investigations, this spread far and wide. Whereas there are indications that, on the contrary, there was confrontation between the M23 and illegal armed groups related to FDC. End of quote. Mr. Vice President, honorable judges, it emerges from all what follows and the affirmations contained in the submission of the DRC that Rwanda was aware of these allegations of the applicant and reacted by protesting against some of the accusations. At times, Rwanda relies on eloquent silence, and when it is blamed for carrying out genocide on Congolese territory. For all these reasons, the applicant praised this court to dismiss the claims of the respondent state and to declare that it has material jurisdiction. While I would like to thank you all for your attention, I'd like to pray you, Mr. Vice President, and the court to give the floor to Barrister Marcel Muchunga to talk about territorial jurisdiction. I would like to thank you.
Vice President, honorable judges, it is a real honor for my modest person to take the floor within the framework of this procedure. I am speaking in my turn following my esteemed colleague, Mr. Jean-Paul Seguioli, to complement the pleadings and submission of the DRC on this aspect of jurisdiction, especially the territorial jurisdiction of the African Court of Human and People's Rights. We have to underline from start that the point is not to address the issue of extraterritorial jurisdiction, of national jurisdiction of the respondent state. As a reminder, the territorial jurisdiction before such a court is understood according to the venue the dispute occurs. In this situation, the question to which we have to answer consists in clarifying whether the court has the capacity to decide on the violation of human rights alleged by the applicant, by the respondent state, while they have not been committed on the Rwandan territory, but rather on the Congolese territory. The answer to such an interrogation that is very important given this situation is facing two contradictory theses or assumptions. The first assumption is supported by the applicant state. The point is to answer by yes, starting on the fact that the violation of human rights were committed on the territory of a state party to the protocol establishing this court. On the other hand, the second assumption defended by Rwanda suggests that the court is not competent insofar as that the alleged violations are not committed on its territory. As a reminder, the scope of this court is determined or defined in Article 3 of its protocol. The latter reads as follows: the court has jurisdiction to consider all the matters and all the dispute referred to it regarding the interpretation and the application of the Charter, the protocol, and all other relevant instruments relating to human rights and ratified by the states concerned. In case of contestation to know whether there is jurisdiction or no, the court decides. The DRC confirms that no reasonable interpretation of this provision can confine the competence of the court to the only case of human right violation committed on the respondent state territory, and this is based on 4 reasons supported by the DRC. First, the literal form reading of this article or provision. Second, the relevant jurisprudence of this court on this very issue. And 3, the jurisprudence of the Commission of Human and People's Rights on this issue. And 4th, the principle of the usefulness of the interpretation of the preamble. Honorable Vice President, honorable judges, the very broad formulation of Article 3 suggests an extension of competence of jurisdiction of the court beyond the territory of the respondent state where violation of human rights occur. From the reading of Article 3 of the protocol, it appears that the author did not deem necessary to limit the territorial meaning or to the territory. On the opposite, it tried to divert from the authors of the ICG and the International Pact on Civil and Political Rights that were animated by the manifest will to limit the territorial competence of the European Court of Human Rights and the Committee of Human Rights to the territory of the respondent state. This stems from Article 1 of the Convention, the Safeguards Convention of Human Rights and Fundamental Freedom, according to which all the contracting parties recognize to all persons under this regulation recognize the rights defined under this convention. Similarly, it is the same for Article 2, Para 1 of the International Covenant on Civil and Political Rights that provides that the state parties to this covenant commits undertakes to respect and guarantee to all individuals on their territory and relating to their jurisdiction the rights recognized under this covenant. What we can say here is that the fact that the protocol have not limited the territorial competence to the jurisdiction like the European Convention, or to the territory and the jurisdiction like the International Covenant on Civil and Political Rights of the state party, is not done by chance. It shows the willingness to assume a broad competence of the court that has established it. This position defended by the DRC and supported by the doctrine in the field shows the point of view defended by an author regarding the African system on human rights, who is very well known, Judge Kibambai, and this is what he says, and I quote: "The violation incriminated has it to be committed in the territory of one of state party so that the commission becomes competent? It doesn't exist in the charter an equivalent of Article 1 of the European Convention, according to which these states guarantee the right of the persons under their jurisdiction. But since there is no limitation regarding the obligation of the state parties to the charter to protect the rights that it recognizes, we have to deduct that the commission is competent even if the violation imputable to a state party occurs vis-à-vis a person protected beyond and outside the national territory," end of quote. It goes without saying that what is done in the commission should be applied to the court, given the complementarity between the two institutions. Similarly, Honorable Judge Blaise Chikaya notes in his individual opinion, which is appended to the ruling of the court Morna against the Republic of Ghana and others, the following: we have to recall the terms of Article 3 that do not exclude any matter from the jurisdiction of the court as long as it is seized regarding the interpretation and the implementation of this charter or any instrument ratified by the state which is pending in terms of human rights. And he says, it is the court that should decide on it. So it is wrongly that Rwanda affirms in its preliminary submission that given the absence of a similar terminology, similar to the one found in the International Covenant on Civil and Political Rights or the European Convention on Human Rights, the court is right to limit its territorial jurisdiction to the facts committed in the territory of the responding state. This affirmation does not come from a wrong comprehension of Article 3 of the protocol, but also and above all from the jurisprudence of the court, which is in favor of a territorial jurisdiction which is wider. The second argument of the DRC, as we said it, is that the lessons drawn from the jurisdiction of the court itself lead to the competence beyond the national territory of the responding state. This court has always retained the status of state party to the protocol and to the charter as a principle to determine its jurisdiction. So the jurisdiction is either explicit, it is the case when the assumption is to consider this issue in a given angle, or implicit when cases where the question was not similar to this case. The territorial jurisdiction of this court is confirmed in a recent ruling that deserves to be evoked within the framework of this matter. So, the court has explicitly affirmed its jurisdiction through two judgments, at least, where the circumstances were calling for a very accurate response on the territorial competence on facts done and beyond the respondent state. In the case of Yakuba Traoré versus Mali, the court deemed that its territorial jurisdiction, it underlines that the alleged violation occurred on a territory of a member state of the African Union. It has, therefore, territorial jurisdiction. This position goes within the framework of its similar motivation as appearing in the judgment of March 2016 in the matter Mogande and 9 others, where the court has deemed that regarding its competence, it deems that given the fact that the alleged violation occurred on a territory of the African Union state, where the state parties are members, so it has jurisdiction to examine this matter. So Rwanda did not mention this jurisprudence, but maybe with some more judgment, we could see clearly that in these two examples, the court has admitted and widened territorial jurisdiction. Indeed, the relevant criteria to declare itself competent needs the fact that the violation were happening in a territory of the African Union, that is to say a state party of the Charter and the protocol establishing this court. It is not by chance, but the interpretation of Article 3 of the protocol is in conformity both to the general nature of its formulation and the will of its author. The other judgments of the court on the territorial jurisdiction cannot be interpreted only on the light of these two judgments. In order to establish a territorial jurisdiction, the court bases itself on the Court on Human Rights, that is to say, one state party, the respondent state, one state party who is the applicant. So the respondent state is party to the Charter, and the state party, or the respondent party. So when we use the term namely, it means that, in other words, among other things, in particular, including, so when the court talks about state party, that is to say respondent state, it means the state party, namely, for example, or among others, the respondent state. Regarding the word namely, it means in this case, in this very case, when the court says the state party, that is to say the respondent state, it means state party. Within this case, the respondent state. So in all the jurisprudence, the court does not contradict itself, and it doesn't question the state party to determine its territorial competence. It only clarifies that within this case, in this case, the state concerned is the respondent state. In short, Rwanda should not always echo the jurisprudence of the court in a selective way, in a hastily way. On the contrary, the reading of this jurisprudence showed that the state party to the protocol and the Charter constitute the criteria to determine the territorial competence of the court. The condition to extend the territorial competence through a specific judgment of the court. In a very precise and accurate judgment in the matter Bernard Mora versus Republic of Ghana and others. The court notes the following, and I quote, contrary to the text applicable to the European Court of Human Rights and to the American Court of Human Rights, the Charter do not precise any resort. The protocol do not define the competence of the court, but the court has always considered and examined its territorial competence. The jurisprudence in the field of human rights has constantly extended the territorial application of treaties beyond the borders and till areas where the state have effective control and where the acts committed by their agents under their military or political influence. Consequently, we can see a consensus so that the obligation to protect or not to violate human rights go beyond the territorial limits of the territories of states. It also notes that the alleged violation of human rights occurred in the territory of the Arab Republic, which is a state party to the protocol, but beyond the national borders of the respondent state. So the court cannot declare itself competent because the alleged violation were committed in a state party to the protocol. To exercise its territorial competence, the court should make sure that the alleged violation were committed by a respondent state or by persons under its control. From this ruling, we can see that in order for the territorial competence to be established, we need two preconditions. That the alleged violation be committed on the territory of a state party to a protocol, first condition, and if the violation of alleged violation have been committed by the respondent state or persons under its control. This is the second precondition. As we can see it, this ruling confirms the constant jurisprudence that its territorial competence is established as long as the alleged violation of human rights were committed on the territory of a state party to the protocol. But the court just added a condition, a practical condition, that the respondent state should be the one where the perpetration of such violation is blamed for that. And given what was said, the court is going to declare itself competent as far as Rwanda has committed and continued to commit violation of human rights on the territories of the DRC, which is a state party to the protocol. The third argument of the DRC is based on the fact that the jurisprudence of the Human and People's Rights Commission is in favor to the broadened territorial competence of the court. There is no determining condition justifying the fact of not inspiring ourselves from the Commission of Human and People's Rights as suggested by Rwanda. And this was demonstrated in the introductive pleadings of my colleague Yvon Mikashi. Indeed, this court is not the only and sole mechanism of protection of human rights who have retained the status of state parties as criteria to determine its territorial jurisdiction. It was preceded in this by the Commission, especially its decision of May 2003 relating to the communication 227/999, which opposed the DRC to Burundi, Uganda, and to the respondent state. In this matter, as in this one, the alleged violation were not committed on the territories of the respondent state territory, but rather on the applicant state territory, which did not prevent the Commission from affirming its territorial competence and jurisdiction. So Rwanda tries to weaken the DRC because saying that the Commission did not really focus on this issue. But how can we imagine that the state party to the protocol can be kept responsible only if it is perpetrated on its territory and not on a territory of another state party? Honorable Vice President, honorable judges, it is the interpretation of Article 3 of the protocol that guides us to take into account the principle of usefulness of this provision. So any possible interpretation that will decline the territorial jurisdiction of the court because the violation of human rights were not committed on the territory of the respondent state would be a very negative precedent for human rights in Africa. This is for two reasons at least. On the one hand, this would mean that would take Rwanda as not responsible for the violation of human rights, and this would be new crimes without sanction. On the other hand, such a solution would mean that we encourage or we entice the respondent state and others to go beyond the national borders of their respective territories, to go and elsewhere and commit in full impunity violation of human rights on the land of neighboring countries, and not to feel responsible of their commitments to the human rights charter. That is to say that Article 3 of the protocol would be empty from its object, scope, and meaning. That is to say the protection of human rights in Africa, and it will be null and void. In conclusion, Mr. Vice President, Honorable Vice President, Honorable Judges, the Court will reject and dismiss the submission of the respondent state and reaffirm its territorial jurisdiction in addition to the material jurisdiction to consider this matter. Thank you very much.
Applicant State, you still have about 10 minutes to go. You still have about 10 minutes. Honorable Vice President, honorable judges, the Council of DRC believe they have brought they made sufficient submissions to the court following the submissions of Rwanda. The court is adjourned for 10 minutes, a 10 minutes break. now the court to put questions to the respondent state. The first question will come from Justice Dennis Dominic Ajay. The questions will go the two parties, and then we'll take a break and give you some time to organize your answers. The questions will go first of all to the respondent state and then to the applicant state. We break to give you a bit of time to consult for 15 minutes, after which we'll come back for you to respond. Honorable Justice Ajay, you have the floor for your question. Honorable Justice Ajay, Honorable Justice Hanukam, you have the floor for your question.
Over alleged violations of rights protected by the Charter or any other human rights instrument ratified by the respondent. However, and therein lies my question, constitutive acts which in the respondent's submission are not human rights instruments, the court does not have jurisdiction over such claim. And the question is, what is your explanation of the word solely? And do you think that the applicant is relying solely on the provisions of the UN Charter, the constitutive act, as you have so claimed? Thank you.
Merci, honorable Anoukam Stella. Honorable juge Shafika Ben Salah, vous avez la parole pour vos questions à l'état défendeur.
Merci, Monsieur le Président. Je vais essayer d'aller doucement, comme ça la traduction va suivre. Vous liez la compétence matérielle à l'existence du différent. Pour vous, il y a une connexion entre les deux termes. La question que je pose, est-ce que votre problème c'est dans l'existence de ce différent, ou alors c'est que pendant le dépôt de la requête, ce différent n'existait pas? Parce que vous avez insisté sur l'existence du différent et le dépôt de la requête pendant l'existence, au moment de l'existence de ce différent. Donc, c'est la question que je pose. Parce que moi, quand je reviens au document, le requérant, il prouve, entre guillemets, c'est-à-dire pour lui, c'est des preuves qu'il présente, pour justement justifier ce différent. Il parle, par exemple, dans le cas de l'Union africaine, il y a beaucoup de choses qui se sont passées et qui prouvent qu'il y a un différent qui a été exposé devant une certaine assemblée. Dans le cadre du processus de l'ANDA, la même chose. Il y a certains faits qui ont été exposés et il y a eu un feedback, etc. etc. Donc tout ça est dans le document et je pense que vous avez quand même pris note de tout ça. Donc c'est ça ma question. Essayez de m'expliquer votre position. Est-ce que c'est le différent qui n'existe pas ou alors ce qui n'existait pas au moment du dépôt de la requête? Merci, Monsieur le Président.
Merci, honorable juge. Honorable juge Mengue, vous avez la parole pour vos questions. Merci.
Merci, Monsieur le Président.
Ma question va dans le même sens que celle de ma collègue qui vient de me précéder. Juste pour demander à sa suite, pour vous demander quand est-ce que vous pouvez affirmer qu'il y a un conflit ou bien qu'il existe un différend?
That there is a conflict between the parties. What is the evidence of the existence of a conflict according to you? Thank you. Menge, Honorable Justine, Honorable Justice Benashu, have the floor. Thank you. President, you aver that the matter is a matter of peace, international peace and security. My question is, the fact that the matter is a matter of peace and international peace and security, as you claim in your submission, does that exclude the possibility of this matter having a greater dimension of human rights? Thank you. Those are the questions for the respondent state. Now, questions for the applicant state. Honorable Justice Ajay, your questions for the applicant state. Thank you.
Thank you, Honorable Judge Ajay. Honorable Judge Stella and Anukam, do you have any question for the applicant, please? Thank you, Mr. President. Honorable Judge Anukam, Honorable Judge Bansulam, over to you. Thank you, Mr. President. I would like to have some clarity regarding the applicant. Could you please, regarding to the application filed, when the facts happened, because you have mentioned several dates regarding the application submitted before us, when did these facts happen? Thank you very much, Honorable Judge Bensala. Honorable Judge Dean, Judge Ben Ashur, over to you. Thank you very much, Mr. President. So the applicant state, an interstate matter filed before the African Court of Human Rights can it be assimilable or comparable to any matter submitted by an individual for violation of a right or several rights of human rights guaranteed by African Union treaties ratified by the states concerned? Thank you, Honorable Judge, for the question to the two parties. So now it is 3:35. We will grant you 15 minutes to allow consultation. So we are going to break for 15 minutes and come back after this period of time so that we give you time to answer to the question in conformity to the order in which the questions were asked. The session is adjourned.